My name is Manny Santos. Welcome to the fine city of Meriden. How many of you have not been to this venue yet? Or before this? All right, wow, okay. So welcome to Il Monticello. The folks here have been really great to us. There's something you should really know. When I was mayor here, I always used to kind of joke about this, but since so many of you haven't been here before, what's interesting about this place is that from anybody that's sitting from on this side of the dance floor, you're actually in Meriden, so you're okay. Everyone on that side, you're in Wallingford, believe it or not. So there's a representative here, Craig Fishbein, who represents Wallingford, so he thanks you too. Welcome everyone to the Connecticut Republican Assembly 4th Annual Luncheon and Convention. For many of you, certainly for many of us, this is the first large political event in over a year now. So really appreciate you guys being here. I know you're excited to get out and about and talk to everyone, all your friends that you've missed. We do have a dance floor, but don't try to dance. So just a couple of house cleaning things. If you're walking around and congregating, wear a mask. The state requires this facility to do that. Angie would be very upset if she got a fine because we weren't wearing a mask as we were walking around. If you're seated, feel free to take your mask off if you're comfortable with that. What else? I think that's about it. Regarding that, the bathrooms are out, the double doors there on the other side of the hall. And I think we could get started. So I think the first thing we'll do our Pledge of Allegiance, and we'll have our CTRA Secretary, Matt O'Brien, lead us in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Born and unborn.
Thank you, Matt. For our opening prayer, we're going to have Dennis Savage come up here, and he is our one of two national directors, and I'm the second one, and also our chaplain.
Thank you, Manny. I'd like to start by reading the scripture that most of us will have heard many times, but can't recite it yet. And it was a quote from Jesus when he was talking to Nicodemus at night. And he said, "For God did not send his Son into the world to condemn the world, but in order that the world might be saved through him." That's John 3:17. So it's our job to tell people about Jesus so that they can be saved through him. And that's one of the reasons this organization exists, is to go back to the roots of what this country was founded upon, the Holy Scriptures. So Father, we ask that you guide us, that you be here with us, that your Holy Spirit be welcome in our midst, and that what is accomplished here will move forward, and the people and citizens of this state will know that we're here to bring them the gospel of Jesus Christ. In Jesus' name, amen.
Thank you, Dennis. Next, I'd like to call up our president, CTRA President Ann Laniski, for a welcoming message. Ann?
Good morning. It's really exciting to see everybody here. I want to welcome you all here to Il Monticello, to CTRA's 4th Annual Luncheon and Convention. The executive board has been really excited to put this together for everyone. We are in a certain state of the state, and we are all gathered here to hopefully work together for hearing the great speakers we have on sanity and going forward to help our state out. And I thank you all very much for coming.
So last year, was it last year? I must have drawn the short straw again, as I'm the MC again. And last year I got a little slack about my jokes. And so where's Marty? Marty Casson, where are you? Marty had me fire my last joke writer. So yeah, I'd like to start with the charity jokes. I've got a stack of them. The first one is on the house, by the way. All right, Marty, sorry. All right. So we'll get to our speakers. We have a great lunch lined up for you. We have breakfast all set up, coffee. Please help yourselves. Be attentive to the speakers as they're giving their time to us. And but feel free to grab coffee and pastries and so forth, and we'll break for lunch at, I believe, 12 o'clock. And you can have the opportunity then to mingle and catch up with folks you haven't seen for a while. And then around 1 o'clock, we'll come back in for the remaining speakers. And then it should be a great event. And then afterwards, we're going to close out and have our annual meeting with all the CTRA members. That's our annual convention, our annual meeting convention. Meeting and convention. In any case, so our first speaker is Attorney Martha Dean. You may recognize her as having been our Republican candidate for Attorney General in 2002 and in 2010. And even briefly was running for governor in 2014. Would have been an excellent governor. She's a constitutional law attorney who actually fights to defend it and our individual rights, and a graduate of the University of Connecticut School of Law. Most recently, in a Michigan federal court, Attorney Dean's firm has been litigating the Second Amendment challenge to the constitutionality of a zoning ordinance that creates an effectively a ban on outdoor shooting ranges. The case is now on appeal in the Sixth Circuit Court. She has worked on bringing top speakers into Connecticut for public policy events at the state capitol. And she also was instrumental, along with Craig Fishbein, by the way, in a lawsuit here in Meriden that I was involved with in the powers of the mayor in being able to appoint the corporation council. We succeeded, so we were that corporation council. The previous one was Betsy was vacated, and I was allowed to appoint someone else. So thank you for the work that you guys have put into that. So without further ado, Martha Dean.
It's great to see all of you. I've been in hiding for a year, mostly with blue jeans on hiking, so it's a real pleasure to put on a suit and a pair of heels and actually be female again. And I'm sure you feel the same way. Getting out and seeing all of our friends and taking our masks off briefly is a real treat. We have a very short amount of time this morning, so I'm just going to quickly go through. I'm going to focus on the U.S. Constitution, rights guaranteed by that, not the state constitution. I've litigated a couple of Connecticut constitutional cases, and I don't spend my time on that. There are other people who can speak to those issues. With a great case, I might consider that, but this focus of this talk is going to be on defending your rights under the U.S. that are guaranteed by the U.S. Constitution. And I'd like to, I'm going to give you a few examples along the way of different cases to illustrate these points. But again, it's going to be very summary. There's little time. So I'm going to assume that you all know the difference between rights and privileges. I'm going to assume that you know, that most of you know what your constitutional rights are that are guaranteed by the U.S. Constitution, but I am going to just mention them briefly to get you thinking. And I'll say at the outset that the rights that are enumerated in the Constitution are not all of our rights. The Ninth Amendment makes it very clear that we have other rights. The fact that some of them were written into the Constitution does not mean that the others don't exist. So, so that's the other thing, is that rights that are written into the Constitution seem to mean one thing, but actually, and you can read the Constitution, which most elected officials don't do, we've learned over the years, but if you read the Constitution, you'll see what it says, and that's an important place to start, but you really don't know what the implications of these rights have been held to be until you read the cases. Now, are you expected to go out and read these cases? No. Will you read some of them? Of course, we all have. But the point I want to make is that reading the Constitution is a starting place. It does not tell you what the list of all the rights that you have are. And I'll give you some examples. And before we get started with that, I just want to say make a couple of big points. One is that the state of constitutional law is changing very, very rapidly again. It did during the 60s. We saw the left, and to their credit, the ACLU and others coming out of the civil rights movement really pushed the First Amendment, and to, some would say to an extreme degree, litigating cases about whether you could have green hair as a prisoner or in prison or as a student in school. Those sorts of cases, some might say, are frivolous or defending the KKK. But the left was very successful in creating great First Amendment law. The right has not been as effective, except for some libertarian organizations such as the Institute for Justice out of Washington. I think it's still ranked, and has been for many years, the #1 charity in America to contribute to. They litigate, they have donors who pay for the litigation, and they litigate constitutional issues. The Cato Institute, I mean, that's been around forever. I love the Cato Institute, another libertarian think tank, but they actually helped to fund the Heller and McDonald decisions and helped create that initial Second Amendment case, and found the counsel for it and funded it to create favorable Second Amendment jurisprudence. So first, the law again is shifting very, very rapidly, and I'm going to read to you a little bit from Judge Silberman's stinging dissent this past Friday on the D.C. Circuit Court of Appeals, which is probably the most prestigious federal court in America, apart from the U.S. Supreme Court. You have all of these different circuits around the country, federal appellate courts, and the D.C. Circuit is where the sort of the elite of the elite, sort of really highly credentialed and excellent judges are sent, and then often nominees for the U.S. Supreme Court come from that court. And he's been there for a long time. He's a Reagan appointee. But the second big point I want to make at the outset is that if you're wondering what your rights are, and you're wondering, how, if a lawyer has to go out and read all these cases to know what the implications of the rights that are enumerated, what the implications are, and what rights we really have, how extensive these rights are, how could I ever do that when most lawyers don't even read the Constitution or know what these rights are? And I would just say this to you. All of you care about your rights. My mask today says, make America free again. We're all here because we care about our rights. And you, when your rights are violated, will have a visceral reaction. It will just be intuitive. You will just know that there is something terribly wrong. Now, you don't need to know which right has been violated. It may be 3 or 4 rights that have been violated. But you will immediately know, just intuitively as a free person, that this isn't allowed, that this is contrary to your right to be a free human being. And that's when you go and you talk to a lawyer, or you talk to other people, or you go and look at some websites for groups that litigate cases that are in that area that you're concerned about. Maybe it's school choice, or maybe it's religious liberties, or maybe it's free speech, or maybe it's campaign donations, financing, whatever it is. And you look around, you talk with lawyers, you look at some websites, and you sort of start to come up with what rights might have been violated. And then that's the beginning of taking action. But just don't underestimate your own ability to know when your rights have been violated. I guarantee every single person sitting here will know, or does know, or has known in the past. So you don't need to have any specialized knowledge other than being a free person and caring about this issue, which I would submit all free people care about. So just going quickly through the various rights. I mean, we all know the First Amendment is religious freedom, the right of assembly, freedom of speech, freedom of the press. And this stinging dissent by Judge Silverman last Friday concerns the freedom of the press, and whether we really have taken that further than what is required by the Constitution in a way that's very harmful to us. The Second Amendment, we all know, is about the right to bear arms. And I would say, and this is just one quick example, our case in Michigan shows how that right is really a bundle of rights. And if you have the right to bear arms, don't you have the right to practice with your firearm? There are two cases in the Seventh Circuit, these L cases, that say yes, you do. But that ends up being in Chicago. And so we're in a very rural part of Michigan. And this very rural Republican township is saying no. They're not allowing any ranges. And then they say, well, maybe an indoor range. Can you shoot at an indoor range with most long guns? No, you can't. And do you have a right to practice over a long distance with a firearm? These are all questions that haven't been sorted out. And they didn't need to be sorted out in the past, because isn't it obvious? I mean, do we really have to litigate everything to establish it? Of course there's a right to practice. Heller says that. The recent Ninth Circuit Court of Appeals case says the same thing. We know as Elle says that, we know there's a right to practice, and yet still, it's almost impossible to build new shooting ranges, even in a Republican-controlled, very rural township. So then you have the Third Amendment. Now the Third Amendment stemmed from the anger that the colonists felt when the King of England forced them to house military troops in times of peace. So you think there's really no application today. But it's the Third Amendment that has been used to really create this right of privacy. So you won't read about a right of privacy in the Constitution, but that is the foundation of it, or the foundation of it being recognized. Its foundation, obviously, is outside of the Constitution. All of these rights in America, we believe, exist without the Constitution. The Constitution doesn't create them. It's just in place to help us secure them. And so not just the right to privacy, but the First, Third, Fourth, and Fifth Amendments have also been used as a foundation to create this idea of zones of privacy. The Fifth Amendment protects property rights. Now, if you go and Google, give me a list of my constitutional rights online, which I did, which was really pretty frightening, you'll see that most educational institutions have lists of constitutional rights, your constitutional rights, and they almost never include your property, your right to property. And they will not mention the Fifth Amendment in that connection. So it's a very important right. We all know about the Kelo case here in Connecticut. I'm happy to say that I received that call about handling that case early on, and I said, you want the Institute for Justice. You don't want me, you want them. That's this organization in Washington that I told you about. And they did an excellent job and still got a terrible, terrible decision out of the Supreme Court. It's mostly been corrected through state legislatures now, but it led to a terrible decision even with the top attorneys in the country handling it. The Fifth Amendment also protects grandfathered rights. So we defend shooting ranges. That's about a third of my practice around the country defending shooting ranges, and so far we've won every case to date. We're still fighting hard. Still fighting hard on appeal in Massachusetts, and one settled. I was amazed. One settled recently in Indiana. Yeah. So the Fifth Amendment protection of property rights is very important when you have uses like that where they're grandfathered. They predate zoning, and then suddenly a town will start requiring you to get permits and sort of inch its way into controlling what a range does and whether a range can exist. So that's one area where we've seen that Fifth Amendment. The Fifth Amendment has been very helpful. And then there's a Seventh Amendment right to a jury trial. Most scholars don't talk about that right at this point. I did actually litigate a case years ago against Terminix, a pesticide company, over this issue, up to a cert petition to the US Supreme Court. So it went that far. It wasn't taken up by the Supreme Court, but there was an adhesion contract, which is basically a contract that you can't negotiate. It was for about $1,500 worth of work. But it had in this fine print, it had a mandatory arbitration clause, meaning you gave up your right to go to court. Now, most people over $1,500 don't think that's a big deal, but when the van for Terminix backs up and kills somebody in your driveway, that's not what happened here, but it was almost that big, what did happen. You know, are you really prevented from going to trial and going to court? And are you really required to go to an arbitrator that Terminix, the company, chooses because 90% of the time it decides in favor of the company that hires it? So we thought it was a really big issue. We teamed up with some leftist organizations who care about jury nullification and the right to a jury trial, and they were wonderful to work with, extremely helpful. We've also teamed up with what we would, on our side of the political aisle, consider left-wing organizations on environmental cases as well, with Bobby Kennedy's group at PACE. And so, we look for those opportunities to work together. I know the Institute for Justice does the same. Many of their issues cut across. They're a libertarian organization, and they cut across left-right divides. And they bring groups together to litigate these cases. They have an incredible success rate on school choice, economic liberties. These cases do present those opportunities, and if you don't grab those opportunities and try to build a coalition that cuts across political lines, it's very hard to win them. There are a number of constitutional rights that protect the rights of the accused. In the criminal law context, I'm not going to mention those. I was going to, but I'm not going to. I don't do criminal law, and I think we all know that there are capable criminal defense lawyers in Connecticut who know those constitutional rights, and they get protected every day through the excellent work that criminal defense attorneys do. So skipping ahead, I just wanted to give you some examples of extensions of rights that we read about in the Constitution, but that you might not be aware of. We personally do, my firm does local counsel work for the National Right to Work Foundation. And if you're not familiar with that, that's just a fantastic organization that has donors who really care about the undue influence of public sector unions. And they were instrumental in getting this 2018 decision, and it was their case, Janus versus AFS-CME. And in 2018, the US Supreme Court held in a 5-4 decision that non-union government workers cannot be required to pay union fees as a condition of working in public service. So that was a big win. Now, for years we've been litigating those cases, and because it was unclear that before that decision came out, which way the Supreme Court would go, we had a very good success litigating those cases with, and the National Right to Work Foundation had a great success in settling them, but finally there's a Supreme Court case that actually says this. More to the point in Connecticut where Dan Malloy tried this a few years ago. For any of you who aren't from Connecticut or only recently here, he's our previous governor. Anyway, in 2014, the US Supreme Court held 5-4, again, that an Illinois requirement that non-union Medicaid-funded home health care personal assistants pay union fees, they held that that violates the First Amendment, that actually is compelled speech, just like, and compelled association, just like requiring public sector employees to pay union dues. But the decisions actually go beyond that, and so, for example, free speech includes paying a campaign donation. that's money, but that's speech. That's been held to be speech. And in the same way, when a public sector union imposes a special assessment or a dues increase, the union has to provide a notice of the purpose of the assessment and the amount, and it can't take any funds from non-members without affirmative consent. Again, that's speech, and to take it without your consent is compelled speech, compelled association. So what means do we have to defend our rights? I mean, lawsuits are the last resort, truly, even though that's what I do for work. Since I've been involved running for office and I've been involved in organizing like you know, we can teach the public, we can write and publish, we can get elected to our school board and start to protect constitutional rights that way. We can, if our kids go to private schools, we can donate to the private schools. We can donate our time to private schools. That gives you a voice. They start listening to you when money and time is involved. To ensure that what's taught in our schools is appropriate. And I'll just give you an example. Just recently, we received a call about a potential action against a public school over critical race theory and the teaching that, you know, that somehow that whites are somehow on a different, should have a different status from non-whites. And in thinking about this, and this is what civil rights lawyers do, they spend their time thinking about legal theories and how to attack these types of issues. And so thinking about it, obviously it seemed like there was a reverse discrimination issue. And if you're familiar with the New Haven firefighters case that Karen Torrey fought, that was one of the first big reverse discrimination cases and successful before the U.S. Supreme Court. If you ask me to explain that case and how she got to the Supreme Court, it's that the path is so ugly and so expensive. How many minutes, Fanny, do I have? One, okay. That you would be shocked. So I'm going to just jump ahead to defending your rights through litigation. Public interest litigation is very, very expensive. If you're doing it to resolve your personal situation, don't do that. It's much bigger than that. Focus on the public policy issues. There are groups all around the country that have donors and that have money to pay for these lawsuits, but they choose the lawsuits carefully. It's slow, it takes many years, it requires a specialized knowledge. It's rarely funded by the plaintiffs themselves. Sometimes it ends up being funded by the lawyers without their consent. We won't go there. But the big takeaway is there are about 240 new conservative judges appointed by President Trump. He did what most presidents do in 8 years, he did in 4. He was just phenomenal, just right out of the gate with the Federalist Society helping him. He appointed phenomenal judges. In the Sixth Circuit, we just had a conference call the other day, and in that Sixth Circuit case, we have Cooper Kirk that was involved with the CCDL litigation here, trying to go up to the U.S. Supreme Court, a top-notch Supreme Court firm, and they said the Sixth Circuit has basically been remade. It's an excellent court now for the Second Amendment. And that's true in many circuits, including the Second Circuit, which includes Connecticut. So there are new judges. There's a Supreme Court dominated by conservatives. We all see how shaky that is right now. There are a large number of well-funded organizations out there to help you. And you'll know when your rights have been violated, so just find someone like me to help point you in the right direction, or you can easily find that direction on your own by just doing a couple of Google searches. So thank you very much for your time, and I encourage you all to call me if you, my number is 860-676-0033. That will direct you through to my cell phone if I'm not at my desk. And I would say that I probably take 10 calls a day from people who I can't help, but I can help them get to another lawyer who can help them, or to the right organization, and I'm happy to do that. So thank you again.